Hello, everyone. My name is Charles Leone. I'm a labor relations representative, and I'm going to be taking you through Investigations 101. This PowerPoint that I'm sharing, I presented this at a court steward meeting. That will be the agency that I'm using as an example, but I'm going to keep these examples fairly general and they can apply to all sorts of agencies. Let me get into it. This is going to be Investigations 101. This is for stewards and members. It's common. The investigation or investigatory interview is something that you may encounter or have your coworkers encounter. What we're going to go over today is basically 4 items here. Pre-investigation basics, what leads up to an investigation, what triggers it, what is a typical investigation, what are the best practices for your employees if you are being investigated or you're going to, someone comes to you and asks you for advice, what's that? I'll also go over what the OCEA rep role is and what some of the things that I like to do and some of my fellow reps like to do during an investigation. And then what comes after it. This is going to flow very, very linearly. Let's get into it here. The investigation is basically brought to you by your wine garden rights. So we're always referencing this. It's very, very important. You all, as union members or union stewards, whoever's watching it, you should be basically familiar with this. Basically, union represented employees have the right, upon request, to have a representative in an interview that the employee reasonably feels could lead to discipline. For the topic that I am discussing, this is the investigatory interview, also known as an investigation or an investigatory meeting. You will be noticed properly. Almost always, HR or your manager or your supervisor will let you know, that it could lead to discipline. They'll also let you know that it could lead to discipline. But as always, if you're going into a meeting, feel free to ask this of anyone you're involved with, a supervisor, management, or HR. Just you can always ask, hey, could this possibly lead to discipline? If so, I would like a union representative. But that's Weingarten. That just basically underlines the investigatory process and your right to union representation. Pre-investigation basics. The investigation will say you'll be noticed of it. I'm going to talk about the actual document that you'll receive, but it'll let you know, hey, you've got an investigation, or maybe your manager or supervisor will let you know in person. Investigation is also called an investigatory interview or an investigatory meeting. Basically, just to frame your mind about this, this is a fact-finding interview. I know investigations are stressful. A lot of what I'm going to talk about is going to be how to kind of manage that stress and understand what an investigation is and what whoever's doing the questioning. Typically it's HR, but it can also be a manager and supervisor. They'll oftentimes work together. What they're looking for, it's a fact-finding interview. So something came up, whether it was reported to them or whether they noticed it, something came up and they want to have an official investigatory meeting that could lead to discipline based on their findings. But what they're going to do in the actual investigation is just ask questions to find facts. What are some typical topics of investigation? Workplace misconduct. That's kind of like your catch-all investigatory phrase for allegedly improper behavior. Work performance. Someone noticed something or something came through where there's a number of errors or alleged errors that they want to look into. A violation of the information systems technology policy, something along those lines. Members will call me and ask me what this is. It basically means your issued technology. So it's alleged that you improperly used your employer issued technology, or maybe you stored some improper documents or something like that. But that's typically what that means. But also remember, investigations can be given for a variety of reasons. These are just probably the more common topics that you'll see. Moving on here. You almost always will be properly noticed of your meeting. You'll receive either a physical copy or an email copy of a notice of investigatory meeting, also known as the NOI. I'm going to go over what to do if you receive one, or you're a steward or a coworker, someone comes to you alarmed because they've received this notice. The notice is very, very basic. It's just that. It's just a notice of investigatory meeting. It will not contain much information. What it will contain is a date of the actual notice. It'll contain a future date and a time and location for the investigation. For example, I used Thursday, June 8th, 2023, 11 a.m. at the Human Resources Multi-Purpose Room in the Central Justice Center. It's just an example. Sometimes investigatory meetings can be held remotely, but it will let you know that notice that you received. So like I said, it will not contain much information. It won't contain the subject of the investigation. It may contain a general allegation, like I mentioned before, such as employee misconduct or work performance, but that's all it will contain. This is an important one. They'll always, like I said, they'll let you know that it may result in formal discipline and that you can contact your union representative. It's always a good idea. Always a good idea. If you receive one of these, contact the union, contact your rep, call us direct as soon as possible, and let us know so we can get involved. I mean, it's always your choice whether or not you want to have a union rep present, but this is what we do. We're here to represent you. So another key fact, some language that you'll see on that notice. This can freak people out. Any notice referencing discipline will typically read something as follows: the investigation may result in formal disciplinary action up to and including discharge from court employment. Again, I'm using the court as an example. This statement is just stating the possible range of discipline. So even though it mentions that word discharge, doesn't necessarily mean that's what the outcome is going to be. They're just saying any discipline from no discipline all the way up to the most severe case of discharge. It's just advising you of that. That's just what the language reads. And then again, it will ask you, the notice will ask you to maintain confidentiality. Do not speak to anybody about the subject of the investigation other than your union rep or the investigator that is interviewing you. So what is a typical investigation? So as I mentioned, investigations can cover a wide range of subjects. They can be very brief. Hey, someone's just going to ask you a couple questions, can take 20 minutes, 30 minutes, even less. I mean, I've had some very quick investigations. I've also had some investigations that can take a long time, several hours at a time, or even multiple sessions, depending on the issue or issues. We'll get more into the time later, just to give you an idea of how varied these investigations could be. The common theme they have is they almost all start the same way. So I'm going to break down how they start, just so you guys kind of know what to expect and how the interviewer is going to lay the foundation for the investigations. So they all follow the basic same initial setup, your introductions, who's involved in the investigation. This is a good point here. You are entitled to investigate, to record the investigation. Not all investigations are recorded. You may decide, you or your rep may decide you want to record it or you don't. You simply need to just inform HR that you will be recording the meeting. What I find is sometimes HR will record the meetings. They will always provide you a copy of whatever that device is. All you have to do is ask. I've never had an HR rep from any agency give me a hard time about that. So you just ask. You're entitled to whatever recording they use or to use your own. So the meetings will start with a series of directives where they will ask you to answer all questions truthfully. Again, they'll say a refusal to cooperate can be considered insubordination and lead to further discipline. Do not be insubordinate. That could be a separate investigation than what you're currently being investigated under. And again, when they reference that discipline, they're going to use that language up to and including discharge. So don't let that freak you out. That's just what could possibly be an outcome. So here's another one that I like to mention. OCEA will commonly ask for a Liebarger admonishment. So your rep will usually go over this with you in detail and explain what a Liebarger is, so you don't get freaked out. This is another one that could sound alarming. It references a court case where if the employee believes that any statement given in the investigation may lead to incrimination or grounds for criminal incrimination, that you may refuse to answer, basically take the fifth. OCEA reps will commonly just have this as a precaution, as part of the directives. It is your right as a union member to decline it if you so choose. It's just part of the procedure, the setup. So again, you'll see me reference the court because I gave this presentation to court stewards, but this can be used as any agency. So they'll ask for your employment history, give you a brief overview of your employment history, what your approximate hire dates are, and what your positions have been held. They'll ask you for your typical schedule. They'll ask you for who your supervisor is. They'll ask you to give a general overview of your job duties. You don't have to get super specific. They just kind of want to know what it is you're doing. They'll usually ask you about relevant training that you've had. This may start to get towards the questions that the subject of the investigation and the questions they want to ask. And then they'll start to, after this foundation, they will get into the actual investigation itself. Basically, what are some employee best practices? So if you are being investigated or you're a steward, an employee comes up to you, they want to know some advice. Again, step one, always have them call your union rep. And this is what we're here for. But as a steward or a fellow coworker, you may want to just you may see an employee kind of panicked or freaking out a little bit, and you can know these things that they'll calm down a little bit, and it can help ease your nerves because sometimes the hardest part of the investigation is the stress. So that's kind of what some of this stuff is designed to help for. So always, this is common sense stuff. Behave professionally. This is a workplace matter. So, polite, professional. This is, you're being directed to answer questions. So that's kind of a gimme. Always tell the truth. Here's a good one. Don't guess your answers. If you don't know or you don't recall, these are perfectly valid responses. Take your time. Keep your answers relevant to the question. Don't generally not a good idea to go off on some tangents and things that are completely unrelated to what's being asked. And don't hesitate to call a caucus to confer with your OCEA rep. This is kind of a break that you're allowed to get, really as many breaks as you want during the meeting. I'll talk a little bit more about this later on. Just some basic ideas. Okay, continuing on here. So some helpful reminders just to know if you're being investigated, or again, to share with your employees if you're the steward. Remember, entitled to union representation. You don't have to go through any of these potential disciplinary meetings alone. We're here. Your reps are here to guide you through that process. You don't have to face a potentially stressful process alone. We'll be with you every step of the way. Again, keep your answers brief. You're allowed to answer. Employees can answer the questions however they want. An important point that I'll bring up, I think I bring up later, the OCEA reps are not going to answer the questions for you. We can't do that, but again, just general advisement. Keep it relevant to the topic at hand. However, if you feel that you need to share some information for context, by all means. Be okay with silence. This is a great one. Oftentimes, so you'll see HR will have a pre-prepared list of questions, and they'll go off that. Sometimes they'll go off the script, but there's oftentimes frequent bouts of silence during an investigation. This is okay. Don't let it rattle you. They're thinking about ways to rephrase questions or analyze your answers. Just know that that's completely normal. Feel free to ask the interviewer to repeat or clarify the question. If you don't understand the question, don't answer it. Make sure you understand it. Your rep is there to help you out with that as well. Don't guess. I already kind of mentioned that. Don't worry about the time. If an investigation goes over the time, it's not uncommon to schedule a follow-up investigation. I've done this many times. Make sure that you're not feeling pressured or rushed. Say what you need to say and take the time that you need to take. You may call a caucus or a break at any time to confer with your union rep, and you can call as many of these as you'd like. The only requirement is that you don't do it in the middle of a question. They want to make sure the question is answered, and then you can call a break to confer with your rep. Sometimes your union rep may call a break as well if they feel the need to, if it's going on a long time, or maybe they have something that they noticed that they may see as helpful. But you can take these breaks, and you'll typically leave the room and just confer in private with your union rep about what's going on. So take advantage of those if you need to. A couple final things here. The employee always gets the last word. All investigations are concluded with the statement, do you feel that there's anything that you need to add to this? And then if you feel that you forgot something or left something out of your investigations, your OCEA rep can always contact HR and forward any information or any documents that you may have left out. So if you forgot something, there's no need to panic. You can get that information to the person that needs it. Okay, OCEA rep role. So this is just an overview, just so you kind of know what we're looking at and some of the things that we do during the investigation. So again, entitled to a rep at any and all potential disciplinary meetings. So the reps will walk you through what to expect, provide you with an overview of your rights or any possible relevant provisions of the MOU that may be in question, or any other provisions that you may need to know. We do this prior to the meeting, whenever it's convenient for you, whenever we can line up the time. During the investigation, the OCEA rep will take notes. We might ask questions from the investigator. Again, I mentioned this earlier. We cannot answer the questions for you. So this is, the employee is being investigated. The employer is seeking your answers. However, we can advise you on kind of the best way to maybe think about your answers. And during breaks or caucuses, we can maybe coach you on what not to say. But again, the employer wants to hear from the employee on the answers. OCEA reps may object. So you may hear us object to certain questions. There's all kinds of objections that we use, but the 5 that I think are typically most common, at least that I use, you've got lack of foundation. Basically, if the investigator doesn't lay any foundation, they just bring in a question out of nowhere without any sort of background or context. Lack of foundation. Where did this question come from? Relevance. This can be similar to foundation. OCEA wants to know, what's the relevance of this? Things like that to clarify, and it's on the record. So we're keeping the HR reps on their toes. This can be common sometimes. A compound question. All questions should come in one at a time. So if you're getting hit with a barrage of questions, you'll hear your OCEA rep say, well, one question at a time, or objection compound question. They shouldn't be hitting you with a barrage of questions. You're allowed to analyze one question at a time. Calls for speculation, also fairly common. The employer may ask you, well, what do you think about this? Or what do you think about what your coworker felt or thought? You may have some thoughts on that yourself, but it's asking for you to speculate. So if you don't know, you can say, hey, I don't know what they're thinking. I'm not in their head. Or your rep may say, like, hey, this just calls for speculation. You're asking them to get inside the head of somebody. Then question has been asked and answered. If you've answered a question, or it's been asked or answered, a rep may say, hey, this has already been answered. So those are common. There's all kinds of objections, but just to give you an idea of some of the things that we listen for as reps. Also, your reps may act as a go-between between the employer and the employee concerning any documents or communications. I kind of mentioned that before. And then, like I said, we're available to advise you on, at the conclusion, where to go after the investigation. What comes after an investigation? Investigations are almost never concluded the same day of the investigatory interview. Lots of people are like, well, am I going to know? Am I going to know? You won't know the day of. They can take weeks or sometimes many months to conclude. So all subjects of that investigation are confidential. That means anything that you tell your rep is also, there's a confidentiality between you and the rep, but do not talk to your coworkers about this. You'll be directed to do this. But one of the reasons why, there's many reasons, but there could be multiple people being interviewed as part of the investigation. You don't want to muddy the waters, and it's a directive. You don't want to interfere or be seen as interfering with a potential investigation. So just keep it confidential. This is an important one. HR management may have additional questions or seek additional information from the employee after the investigation. This could result in either a follow-up investigation, or they may just ask you, hey, we've got a few questions. Can you answer these via email? They will almost always CC the union rep, but make sure the union rep is CC'd on all communications pertaining to the investigation. If you are asked questions after the investigation that are relevant to the investigation, that is still considered part of the investigation. So your union rep needs to be present and needs to be witness to what is being asked. And again, they may jump in, even if it's done via email. They may jump in with some questions of their own or objections of their own. That's just a note. CC your union rep on all communications. And then as to the determination of the investigation, the employee will typically be contacted before the union rep. So they'll reach out to you before they reach out to us, almost always, not always, about the results of the investigation. Regardless of the outcome, I'm going to go over possible outcomes in a minute here. Regardless of the outcome, contact your union rep and keep them in the loop for communications about receiving the possible outcome of the investigation. For many reasons, we like to. The most important is that if it's an appeal right, there is a time limit to your appeals. So this varies based on your MOU, varies based on the type of discipline. In your MOUs, this will be under the section known as grievance, so you can follow them. For example, to file an appeal in the next slide, for a written reprimand in the courts, you have 14 calendar days within the incident to do so. So you'll have different examples for this, but the point is contact your union rep immediately because there is a possible time discrepancy with filing an appeal. Okay, possible outcomes of an investigation. So just some general outcomes. I kind of touched on it earlier. No wrongdoing. Hey, this is awesome. Best case scenario, the employee will be informed that the investigation is over. No wrongdoing. Case closed. Let your union rep know anyways. The employee receives a memo of expectations or a counseling memo. Now, this is not considered formal discipline and it's not grievable. You'll see, again, I tailored this towards the superior court. So there's slightly different rules depending on the agency, depending on the city or the district or the county. These are very general. These can be called, they're called summary of conferences. Sometimes they're called counseling memos or counseling meetings, memos of expectations within the county and the courts, but this is not considered formal discipline. This is, therefore, it's not grievable. So it's just a counseling memo. Hey, it doesn't count as progressive discipline. However, it might be referenced in a performance review, an annual performance review. Generally speaking, you're allowed to write a rebuttal just so that your take on the events, if you disagree with it or you want to add context, that can be added or referenced in that annual review. Now, again, I tailored this towards the courts. So the best thing to do would be to review your MOU or just contact your union rep and have your union rep review the specific MOU for the agency to go over the specific timelines, when to file a grievance or an appeal. Not all agencies will have the exact same steps of progressive discipline. They don't always call things the same, but these rules are general and apply to most agencies. So as always, contact your union rep with questions. Okay, now we enter the formal discipline process. You've got basically your 3 stages. You've got your written reprimand, which is the lowest case of formal discipline, may be appealed through the grievance process. Again, check with your rep on the timelines. You have your suspension. These can vary with length, and they're given with or without pay. It varies. And the length also can vary. Also considered formal discipline and may be appealed through the grievance process. And then the final and most extreme step is, of course, the discharge or the termination. This, of course, can be appealed. And obviously, with any of these, please contact your union rep right away so they can advise you on the best course of action to take. So one more thing to bring up, somebody had brought this up during our court steward meeting. Another possible outcome, this is usually a pretty serious scenario if this happens. Prior to receiving a decision from the investigation, you may be placed on something called administrative leave. Again, this is usually only in the most paid administrative leave, excuse me, only in the most extreme cases. Basically, what it means is that it will be detailed. You'll be noticed. You'll receive a document informing it, but it means that you're on leave with pay, but the employer doesn't want you to come into the facilities or be around the facilities because they're continuing their investigation. So, and it'll say you typically need to be available during business hours, 8 to 5, as you are getting paid. So you will need to be available to come in and answer your phone or respond to communications promptly in case needed. So again, contact your union rep. If you get to that stage, you will almost certainly have union representation that can walk you through that. But that is a possible outcome, and I bring that up because that was a question that came up in the court steward meeting. All right, folks. So thank you for tuning in. You can contact me or anybody here at OCEA. We're happy to answer any questions you have. Hopefully you found this training to be helpful. And remember, contact your union rep.